Morning all. We're here for an appeal hearing in the matter CA-013 2016 before the Chief Justice Michael Hwang, Justice Sir Jeremy Cook, and His Excellency Justice Omar and Muhairi. The appellant is represented by Hamdan al-Shamsi lawyers and legal consultants. Lead counsel is Roger Bowden. The respondents are represented by Taylor Wessing Middle East LLP. Lead counsel is Nicholas Carnell. Assisting is James Baldwin.
Good morning, Your Lordships and Your Excellency. I appear for the appellant. The first matter which would arise, sir, is my application, sir, for a subpoena duces tecum, or witness summons, in relation to Ms. who is the legal manager for Union Properties, the original vendor of the subject properties, Your Honours, who has answered the informal summons or the direction sent by the court yesterday and is sitting in the back of the court, sir. And I understand from the registry that that will be dealt with as a preliminary matter, and if the application is granted, the matter can be proceeded with immediately.
Why don't you go through the total agenda, then we can determine the order. I've got down here, there's an application for admission of the fourth witness statement of Mr. Naki. There's an appeal against the order denying third-party disclosure order against the Registrar of Real Properties, an appeal against the order denying third-party disclosure order against the Registrar of Companies, and appeal against the order imposing security for costs, and I presume against the consequential stay. And fifth is an order which perhaps is consequential, but it's on the subpoena duces tecum on Pjsc of Union Properties, which is the most recent application. And you want to take it first, I suppose, for the convenience of Ms. Bushra, right? Mr. Carnell, any objection to that order?
Indeed not, Your Honour.
The order in the sense that we deal with Ms. Bushra first.
We'd quite like to deal with these so-called first, because we see no reason why Ms. Bushra should be coming around any longer in absolute custody.
Just provided that nothing in that argument turns on any of the things that other things that we're going to argue about. That's the only thing. Why don't we see how it goes, and then we'll see if we can deal with it isolated from the other. I mean, by the way, have I covered all the
Yes, indeed,
other items that we have to deal with? Yeah.
Very well, thank you, sir.
I'd just add, my Lord, that it's entirely possible that there is going to be some, if you like, cross-pollination between the various issues. But we'll comment, let's see how we go, is entirely appropriate.
Yes. So, Mr. Bowden, you will
Thank you, sir.
elaborate.
In that case, sir, my starting point would be in Volume 1, Tab 10. Sorry, sir, just as a matter of form, how do you prefer that I address the differing judges before the courts?
I think the custom is Your Honour.
Your Honour, thank you, sir. And that, sir, is the application to adduce the new evidence upon appeal. And that, in turn, refers, sir, to the fourth witness statement of Mr. Naki Al-Khalali, sir, who's the director of the appellant company. And that document can be found at tab 18, sir.
Right, but we need permission for this fourth witness statement to be introduced as well, isn't it?
Well, I do wonder about that, sir, because there was an order in relation to that fourth witness statement, and that's under tab 3 of volume 1, dated the 3rd of January. But I'm more than happy to reapply now, sir, because it all...
I think actually we are rather interested in having more information to fill in what seem to be gaps in the evidence that we have so far. So I think we are not likely to dwell on technicalities. And let's have a look at Mr. Naki's fourth witness statement.
Thank you, sir.
If you want to refer to that to explain why you need this subpoena.
Right. Very well, sir. This in turn relates to the witness statement of Mr. Carnell, which was dated the 8th of September, sir, and filed in support of the original first instance application for security for costs. And in there, sir, Mr. Carnell deposed, and I'm at paragraph 3 of the witness statement, says, furthermore, the sale and purchase agreements transferring possession of the various units from Union Properties to ENDB did not disclose the existence of the unregistered lease. And as a point of fact, that is in dispute. And we say, sir, that the matters sought to be introduced by, indeed, the witness summons today fill in that gap in the evidence or resolve that dispute and in a way which is decisive in relation to the entire case.
I'm sorry, I'm looking forward to paragraph 9.
Yes.
You talk about this letter, but you don't have a date for the letter. Presumably you are referring to the letter in paragraph 8. Ms. Fernandez to the Registrar of Companies. Is that right?
Yes, I am. And I apologise for the imprecise language. Now...
Sorry, but how does that relate to the subpoena?
No, it's only, sir, going back to paragraph 5 of the witness statement. So if we take you through the witness statement, the subpoena, Your Honours, relates to paragraphs 3, 4 and 5 and 6.
Right, let's go back to your application then. What you want is the Excel sheet.
Yes, I want the Excel sheet, sir, and the master sales agreement, which covers it all. There was another point made by my learned friend in his witness statement that the two agreements for sale and purchase of these individual units did not refer to any leases. They didn't have it they weren't registered against the title, and nor were they mentioned in the agreement for sale and purchase. We say that there's good reason for that, that we expect to find them in the master sales agreement, which is the subject of the witness summons. Okay. Now,
this is quite a limited point, isn't it? Because
yes,
you've seen the copy of the Excel sheet, you've seen the reference to leases for units 5 and 6 on that, and this is simply to have the original, which puts the matter beyond argument. That's really what it comes to.
Precisely, sir. And indeed, the application for the summons was triggered by a submission from my learned friends, which said that there were some question marks over that document. So to put the issue beyond doubt, it's best to ask the person who's in possession of the document, or at least a fresh copy from their computer, and can verify its bona fides to bring it along and introduce it via the summons, sir. Nothing more is sort of achieved.
Right. So where is the application for the subpoena again?
That, sir, can be found. Well, if I might have the indulgence, sir, of just taking the court to the letters in question, the letter dated the 18th of December, which originally attached the Excel spreadsheet, but did not in the version that we received from the other side, sir. And that is, if we go to volume 2, volume 2 is all of the evidential documents in the witness statements, which have been detached from the witness statements, reorganised and placed in chronological order. And over the left-hand side shows them in chronological order, sir. The right-hand column of the index indicates the source of them, and there is a supplementary index which lists them according to the source document. Thank you. And so the date of the document, sir, being 18 December 2011, that comes in at tab 14.
Yes.
And this is the offer letter to your honours to sell the units in the Index Tower and Limestone House. And just by way of background, I assume that the court's familiar with the geography of this dispute. If one was fortunate enough to stay in the hotel adjacent to the DIFC, the Ritz-Carlton Hotel.
We know where it is in the sense that it's next to Ritz-Carlton. Is that,
yes.
Do we need to know anything more than that?
No, indeed, sir. Limestone House is really part of the same building. It's the far end, sir. It's the southern end, the Abu Dhabi end of that building. And indeed, Your Honours, if Your Honour are familiar with that courtyard, shisha smoking bar, I think it's called Belge Cafe, which is an outdoor area where one can repose of an evening. If one is sitting down there and looks up down towards Business Bay, the courtyard is surrounded by sort of a walled area.
This is the courtyard of the Limestone House itself,
yes.
not the Ritz-Carlton.
I think you can enter it through the Ritz-Carlton, sir. From the lobby, you walk out through the doors and into it, and it's got stairways up out of it, back onto the podium level. But perhaps I put it this way: if
that's the number 5 terrace. Are you talking about?
That would be right, sir.
Okay.
That terrace area up the top, and it's at the Business Bay end of that terraced area, up above that bar down below. And that is where the two units are, on that terrace. And I understand at the moment, sir, there's construction work going in to sort of fill in the boulevard that runs down between all of the buildings. And those units, sir, will walk out and onto that rooftop boulevard which has been created there, sir.
Right. So, the two units exist or don't exist?
Well, they exist, sir, and they're still vacant and still owned, as I understand it, by the respondent. Thank you. So, Union Properties were the developers of the entire building, and at this point we're arranging to sell the entire building in 2011 to the property arm of their bank, perhaps for obvious reasons. And the only thing that needed to be added to it was an Index Tower, which is a large tower further south, but within that same big block, within the DIFC as well, was also added in, and that's I think a mixed-use but mainly residential tower with several hundred units in it. That was being sold as well. Thank you. And this is the offer to sell, and most importantly, this is on page 2 of the letter, which is page 124 of the volume. It says that the two master sales will be signed, and then it talks about at 6. Sorry, I should go to 4. During this period, individual SPAs will be signed. So there's provision for both the master and the individual SPAs. It deals with costs and the transfer of the titles. But importantly, title deeds. Once survey is completed, the deeds will be issued by UP. So at that stage, the units were called LP5 and LP6, but they were subsequently registered and became 17A and 17B, but there's no great mystery there. And then over the next side, sir, 11, the next page, my apologies. The next page is, please find attached an Excel report with the exact units to be included in the purchase offer. Again, slight variances in the inventory may occur, but the key point is that the letter originally attached an Excel spreadsheet. And if we go over one tab, we have what we understand, and indeed the subject of the summons is this Excel spreadsheet. And we don't believe that there are any, we don't have any queries about it, but it will put the matter beyond doubt if Ms. Busher can present it to you. I would only add that in relation to a subpoena duces tecum, it's not anticipated that I would be asking any questions in relation to it. I don't have any. So, and then I think it's pretty self-explanatory, sir, but 5 and 6, it's not a very good copy, but they indicate that the units were leased. And I think it might be useful to then go to the letter of acceptance. And that is that UP, that's on the next tab 16. Number 1, UP undertake, it's worded rather strangely, but it's the offer that it asks that UP accept the below mentioned conditions, and that is that they're all completed, that UP owns them, UP agrees to the handover terms, that the purchase price is agreed, the fees of the DIFC, and then 6A, execute sale and purchase agreements, the transfer of all the title deeds, C, all the infrastructure works, and D, which is important for this case, agrees to assign and transfer the rent amount of the rented properties. And we will come back to that because it's our case that part of the proof, if one likes, of our client's tenancy in this building is the fact that the rent checks which it had made out to Union Properties were transferred in accordance with this agreement and were in fact subsequently attempted to be banked by the respondent. Thank you. That takes us down to D, and then seven just deals with refunds. 8, conditional offer. Then, sorry, it is an offer. I actually deal with it in more substance in the skeleton. I'll reserve it for that if I may. But I think it is really 6D. UP agrees to assign and transfer the rent amount of the rented properties in the 2 buildings from the date of paying any rent amount by UP on or after the date receiving the total purchase price will be transferred to ENDB, to the respondent. And that letter was written after receiving the said spreadsheet. So there, so that really covers the evidence of Mr. Al-Khalili. And that's 4, 5, 6 and 7 of his fourth witness statement, which is on page 100 of volume 1. Then the next document, which is of relevance, sir, I think if it's all right with the court, if it's acceptable to the court, I'll just go straight over to the next tab and perhaps come back to the application in a minute, because I think the application is perhaps best expressed in the witness statement, and it reads as follows. So I'm on volume 1, page 103, and that's paragraph number 2. I am making this witness statement in support of an application for the issue of a witness summons to Ms. Bushra Muhairi, the manager of Legal Services Union Properties, asking her to attend the Court of Appeal on the date set for hearing and to produce the following documents. 1, the Excel spreadsheet. 2, the master sales agreements, both being the documents listed in the letter that we have just looked at. But a little bit of background, sir, the entry into the 10-year lease with Union Properties, and we'll come back to that, Your Honours, but there's evidence in the file that Union Properties say that was a good lease. We have no problem. We regarded it as valid. The issue in this case is whether Emirates NBD contracted to purchase the units subject to the lease or equitably bound, and this is a reference to Article 31 brackets H of the Law of Real Property from the DIFC, which we'll come back to accept the lease due to some other conduct by them. The present appeal is against the order that the claimant pay security of costs. The appellant's case is that it should not have to pay security, as it has an extremely strong case. Purpose of this application: the purpose of the application is to ensure that verified copies of the 2 documents are before the Court of Appeal when it hears the appeal on Monday 6th of March. And coming over the page now to page 104, having verified copies of the 2 documents before the Court of Appeal is intended to establish to the requisite standard that the respondent purchased the units subject to the lease in place. And indeed, the very purpose of the subpoena is to ensure that the court has the best evidence before it, no other purpose. The Excel spreadsheet, annexed here to in the matter marked with the letter A, is the Excel spreadsheet, and then there's a bit of discussion about that. And this comes back to His Excellency's order of the 3rd of January. The Excel spreadsheet has been admitted, but we're dealing with the matter anew, sir, afresh. 10. However, by the respondent's application for a stay of the first instance proceedings, dated 3 November, the respondent has sought to discredit the new evidence by saying at 14.3, I can provide the page reference to that. That will be at tab 37.
Which volume?
Sorry, sir.
Sorry, which volume?
Volume 1. My apologies, I was going to the wrong place. Number 9, tab 9, Your Honours. And
what is the tab number?
tab 9. and it's page, so volume 1, page 29. Paragraph 14.3. And it's never an excuse, Your Honours, but I was in this court in a freezing application until 4 o'clock yesterday afternoon, and the time to properly refamiliarise myself with this material just didn't present itself, and I do apologise for that. 14.3. There are question marks over the credibility of this additional evidence. So that is what gave rise to the fifth witness statement of Mr. Al-Khalili, and so we're back to that document at 19, page 104.
You say 19?
Yes, sorry. We've just gone to the source of the question mark, back at tab 9, and now I'm hoping to direct your attention back to Mr. Al-Khalili's witness statement at tab 19, page 104 of volume 1.
But the real question at the end of the day is, does this do you enough good in the context of the applications that we have to deal with? On the face of it, you had an arguable case in relation to the letters of the 18th and the 26th in the Excel spreadsheet, some doubts being cast on it. You say this makes it cast iron. But the real question at the end of the day is just how much good does it do you in the context of the applications that the judge had to deal with and we have to deal with? Does it really help, in other words?
I absolutely.
That you've got a strong case on at this point that the purchase was subject to that so far as the purchase agreement was concerned.
And our position, my Lord, is that establishes liability, if not. It doesn't deal with the issue of damages, but it establishes the liability in relation to...
You say Article 31H, you satisfy that in full just by reference to these documents, do you?
Well, yes, sir. If the respondent contracted to buy the units subject to the leases which were in place in relation to those units, and there was proof of that.
That's the ultimate question, isn't it?
Yeah.
As against the non-registration.
The non-registration, in my respectful submission, is irrelevant. The registration of the lease doesn't add any force to the lease. It's conclusive evidence of notice. So the registration is conclusive notice to any purchaser that there's a lease in place and that they will be bound by it. But in this case, the underlying units weren't registered. The parties dealt with the issue of notice by contract, and that's conclusive between them. No, the registration is, in that respect, a non-point.
Well, let's come back to the question of the significance of registration. I think that might not be so relevant when we're talking about this first question of the subpoena. So just finish off your argument about what these two documents will do for your case.
Very well said. So I'm back at 104, page 1. The respondent, despite being taxed about the matter, hasn't really said anything more about what problems it might have with that Excel spreadsheet, and so the application was made. If we move down to the master sales agreement, that's at the bottom, 14, the master sales agreement. At the same meeting on 5 December, I was shown a copy of the master sales agreement. That document provides, from my recollection of it, that the sale of the units in Limestone House and Index Tower from Union Properties is subject to any leases in place. So, whilst the offer letter attached a Excel spreadsheet showing the leased units, and the letter of acceptance appears to accept the offer subject to those documents. All agreements were subject to contract, and the master sales agreement, as we understand matters, is that contract which conclusively settles the issue. Did they purchase it subject to the lease? And that is the reason for wanting to introduce that document. So it really proves the point. If it's signed by both parties, it's been given effect to. We know that the underlying units have subsequently been registered. And in our view, Your Honours, that's the end of that argument. And we're quite happy to deal with the lease argument as it arises.
Yes, anything further?
Well, there is, sir. My learned friends then put in a submission, and that is at tab 37, and we then filed a response to that, reply submissions, and I do apologise, but that didn't make it into the bundle. But I have it. It was filed and served, but it wasn't bundled. And if it's acceptable to Your Honour, Mr. Chief Justice, I will hand it up now, and it has tabs ready to go.
Yes, Mr. Pardon?
Yes. Well, that briefly deals with all of the arguments that I think we've dealt with here, and I don't have any particular matters to raise in relation to it. Unless there's any questions that the Court has in relation to that document, I'm quite happy to rest my argument there.
Mr. Parnell?
Thank you, my Lord. Can I start by just asking the Court to remind itself that this argument arises primarily in the relation to an appeal against an order for security costs. I don't know whether I need to take you to RDC 25.110. I'm quite sure your Lordships know the provision off by heart. But if I just read it out for the record, it reads, investigation of the merits of the case on an application for security is strongly discouraged. Only in those cases where it can be shown without detailed investigation of evidence or law that the claim is certain or almost certain to succeed or fail, will the merits be taken into consideration. What we've heard over the last 30 minutes or so essentially is a journey into the merits, and a journey which Mr. Bowden says will be dispositive of the claim in its entirety. We say that just plainly isn't right.
Can I sum up the position correctly? That at
You
the
summed it-
end of the day, you're looking at the question of non-registration against the effect of these documents?
You summed it up absolutely perfectly, and I'm not. And I think your point is.
And you're prepared to accept, for the purposes of argument, that he has a good arguable case, or you can put it almost any level you like, in relation to his Article 31H point, with or without these documents.
Subject to one thing, my lord, which is that the Article 31H point has never been pleaded.
I understand that. I think we're dealing with things where they are,
I think that's right.
Today, regardless of pleadings. Pleadings can be put right, can't they?
They can have.
The issue has been raised, hasn't it?
The issue has been raised, and you're absolutely right to say that. We simply say, for the sake of completeness, that it hasn't been raised, which is why we have not dealt with it by way of an amended defence.
Understood.
What you say, and your point is absolutely correct, is that we would accept that there is an arguable case. We do not, for a moment, accept that, if I can use the expression "slam dunk," that it's a slam dunk, and we can illustrate that very simply by looking at one point which Mr. Bowden took you to. He referred to a letter of acceptance. If I could just ask your lordships to go to page 127 in tab 2. I should say that I hope this is going to be the first and I hope the last time that I'll need to go to bundle 2. But just if you can turn to page 127. I don't need to take you very far into this document, but I do ask your lordships just to look at the heading, please. It's described as conditional offer. It's not an acceptance of the 18th of December offer. It's a fresh offer. We say it does not follow that this has the effect of importing the Excel spreadsheet, so named, and does not have the effect of automatically importing the terms of that document into the terms of the transaction which was eventually concluded. That, my lords, is going to be a matter for evidence in due course, and it may be a matter for further disclosure, and it is a matter which will need to be investigated. Say it certainly does not, as Mr. Bowden seems to be suggesting, mean that his unpleaded case on Article 31H acquires any sort of force. Again, it's a point to be investigated.
And no doubt we'd want to see the response to this letter. It occurred to me immediately I read the letter, but we're in a slight vacuum at that point, and that's why, for current purposes, the court presumably has to proceed on the basis that each side has a, quote, strongly arguable case or something to that effect, without investigating the merits.
Well, I think that has to be right. I think what you would also be what I would also commend to you is the position where you would say, on the basis that each side has a strongly arguable case, we are in what one might term Porzelak country, and that being so, we then come back to the real nub of the security for costs application. But let me deal with this application which is being made here and now. At the hearing before His Honour Judge Shamlan at first instance on the 20th of September, there was an application for third-party disclosure directed against the two registrars and against Union Properties. Judge Shamlan dismissed that application, and his reasons for doing so are set out in the schedule to his order. We say his reasons for dismissing that application were entirely proper and were because the order was couched in too wide terms. That, we say, is an unexceptionable decision. Now, the dismissal of the orders against the two registrars was the subject matter of Mr. Bowden's appeal. The application for third-party discovery against Union Properties wasn't. What we have today is an attempt, really by a sidewind, to revive that application. It's an attempt to circumvent the order for security for costs which was made. We said in the submission, which you'll have at tab 37, that this application is premature and that precisely the same analysis which Judge Shamlan applies here. This is premature. Upon standard disclosure taking place, when it takes place, these matters may be addressed. But for Mr. Bowden to suggest that he has a quick and certain route to guarantee the end of the case is, I would submit, a submission which your lordship simply cannot accept. That, I think, is about all I need to say on that part of the application, save for this. An issue which doesn't seem to have been addressed at all is, in the event that your lordships grant this application and the master sales agreement is produced, what are we then supposed to do with it? Is it supposed to form part of today's substantive appeal against the security for costs order? If so, one questions how the respondent is sensibly supposed to deal with this matter on the run. This is not a document which is in these proceedings. It is a document on which we would need to take instructions, and sensibly there is no way in which the matter could really be dealt with today.
You've had this document in your possession for how many years?
It is presumably in the possession of Emirates National Bank of Dubai. I haven't seen it. The persons with conduct of this matter at Emirates National Bank of Dubai have not at this point located it. We have taken a view that this is a document to be produced on disclosure when that happens. We are concerned that there should not essentially be a mini trial with the huge waste of costs that is going to entail. Unless I can help your lordships further, that was, I think, all I proposed.
I think the court would like to see these documents, so we will make an order in terms. There is a small request, I think. You want some money?
Yes, and
A witness allowance fee, presumably, is it?
indeed, sir. My client has bought the conduct money this morning.
But that will be paid by your client first, won't it?
I'll give it to the registrar now. If I think my client is obtaining a loan.
Okay, so we'll leave your colleagues to deal with that issue. Oh, I see. Flashing around money in
If I
court.
may approach the registrar.
Right, so we've disposed of that particular issue, and we'll move on to the next issue. In what order do you want to take the next issue?
I think I would feel most comfortable if I now started my skeleton from the beginning.
Going to the main issues of the appeals against Justice Shamlan's various orders about disclosure?
Yes,
And then we'll come to security in the later part.
exactly.
Yeah. So we'll deal with these arguments about disclosure of particular documents, and then Mr. Carnell can reply, and then we'll see whether or not we want to make any order at that stage, or we'll carry on and listen to the arguments on security first before making a comprehensive order. Okay?
Thank you. Thank you. Starting at 1 is the absent the.
I'm so sorry. I think we have also incidentally dealt with the application for the fourth witness statement of Mr. Naki.
Thank you.
So we're going to admit that, and then let's move on from there.
I'll be at. I think I should just start at 2, paragraph 2 of my skeleton argument. The document I'm working from is should be on the cover page. Got amended 5 February. Still,
Volume 1, isn't it?
is
Tab 13, gentlemen.
This is the revised skeleton.
yes. I regret a few errors of mine on the cover page.
That's okay.
It should have CA-013 bar 2016, and it should be skeleton argument in support of appeal. I've left it as application for leave to appeal, something that I've belatedly discovered, much to my embarrassment, and I apologise for that. But
Yep. Go on.
I did leave it in substantially the same form as Your Honour's Chief Justice granted leave upon, but expanded and hopefully improved it.
Please carry on.
So that would take, and just, I guess in the index, just dealing with the format of it, briefly touching the exercise of the discretion, the hearing, the contractual matrix, the contention of the party, and the issue which His Lordship raised about the lease at pages 7, and then getting into the security issue. Thank you. At paragraph 3, all limbs of the appeal are against the exercise of the discretion. In addition, this is an appeal against the case management decision and the considerations in RDC 44.31 apply. And that is effectively that it. I recognise that some aspects of case management decisions aren't amenable to appeal, and that is an additional hurdle which we have to face. And The hearing on the 20th September 2016, there wasn't a transcript, but I don't believe that anything particularly arises from that.
I think we are more interested in what is the evidential significance of the documents that you want. If you get to that, then I think we can make a decision.
Very well.
I don't think you need to argue too much about the extent of the Court of Appeal's normal practice in reviewing case management decisions. I mean, we are where we are, and it's come this far, and so we might as well settle this issue
very
today
well.
if we can. So we really want to know what the importance of these documents are and how they will fit into your theory of the case.
There is one point at 6C which I would draw the Court's attention to in relation to that matter, and that's that it was in a hearing in the Court below that there was discussion between my learned friend and the presiding judge as to the significance of the two agreements for sale and purchase which are set out at tabs 18 and 19 of Volume 1. So, as we've seen in the scheme of the letter, it was anticipated that there would be individual sales and purchase and master sales agreement over the top. And Ms. Bushra has the master sales agreement in her possession, I understand. So, at the initial hearing, we only had those individual sales and purchase agreements. And the point was made, those individual sales and purchase agreements don't say anything about it. So when it came to the assessment of the strength of the applicant's case, or the then respondent, the appellant, I'll stick to appellant, thank you, of our case, there was really no consideration given to the master sales agreement and what that might say. And some consideration was given, unduly given, or undue weight was accorded to the individual sale and purchase agreements. The contractual matrix, so I'm now on page 52 of Volume 1. The appellant entered into...
Right, just interrupt you a minute. The sale and purchase agreements, the individual sale and purchase agreements, were in respect of the units numbered 17A and 17B.
That's correct, sir.
And it's not in dispute that 17A and 17B refer to what used to be L5 and L6.
I don't understand, so no.
That is correct, my lord.
Right, okay. Please carry on.
And the difference between them is the subsequent registration gave them new numbers.
Okay.
The appellant...
Sorry, in the sale and purchase agreements, what are they described as?
17A and 17B, because the letter said, my learned friend calls it, I think, a counter-offer. The counter-offer letter from the respondent said, you will attend to registration of these units. And that was obviously done, and then they were transferred as the registered units 17A and 17B.
So by that time, the strata title plan had been issued?
I understand, yes, sir.
Because that's when you usually get the definitive numbers.
That's exactly right, yes.
Okay?
So at the beginning, the underlying title was unregistered, and it'll be my argument that that's got an obvious consequence for the lease. Thank you. 7. The appellant entered into a binding lease with Union Properties on the 1st of October 2010 for a period of 10 years.
Just to interrupt you again, sorry.
Absolutely, sir.
10 years, fixed rent for the 10 years.
Yes.
No,
sorry, it was set to increase over that time period.
there were reviews set at periods of, 2-3 years?
I understand. Can I just check that too? I think it might have actually specified a rent right through to the end date. Every 2 years it went up by the amount specified in the lease. Up to
The
end
fixed
date.
amount or a percentage? Or?
Fixed amount.
Okay, go on.
This lease is acknowledged as valid by UP.
Sorry, what is the area of the units, the total area?
I'm getting instructions on the run. I hope
Sure.
that that's acceptable.
Your client's behind.
2,900 square metres. 2930 square metres, indoor and outdoor. 2,930 square metres of indoor space.
It's quite a large.
Yes. And Vegie Bar, just to fill in a gap, is Vegie Bar is a large and I understand very successful food establishment in Melbourne, Australia, and so it's a license obtained from Vegie Bar Australia to operate here. Not a franchise, but a license. Thank you. There was a slight change in that there was initially, it was for units 1 and 4, and at the request of Union Properties it was moved to 5 and 6, but I don't think anything turns on that. And so that takes me to footnote number 4. This first lease was later terminated by agreement, and a new lease entered into in the same terms but for different units, then called 5 and 6. 8. By letter dated 18 December, UP agreed to sell the 302 units across the 2 buildings that we've been discussing, and the subject units, later renamed 17 and A and B on registration, were included in the sale as part of the 25 units sold as limestone retail. 9. Both vacant and rented units were offered for sale, and at paragraph 11 of the 18 December letter, there's reference to an Excel report with the exact units to be included. 10. This Excel spreadsheet, which has been admitted as new evidence on appeal, records those units as leased, and we've looked at that. UP's offer to sell was accepted by the letter dated 26 December 2011, and again which we 16 of volume 1, which included an invitation that UP agrees to assign the leases and sign square brackets, that's my addition there in the square brackets, assign and transfer the rent amount of the rented properties in the 2 buildings. I have interpolated the square brackets, thank you, as saying that it refers to the leases, just for clarity. 12. A master sales agreement was subsequently executed, and that document included the leases as part of the sale.
How could you make that statement if you haven't seen it?
Well, I've footnoted it to Mr. Naki's 5th witness statement, and going back to page 102, and that was, and it was also dealt with in his 4th witness statement, where he sought to admit that piece of evidence as hearsay evidence. So it's hearsay evidence from Mr. Al-Khalili, sir, and it was identified as such in the 4th witness statement, and the reference to it there is, I'm very much hoping, will confirm that it is indeed, sorry, we'll go straight to it, shall we, sir? Volume 1 through to tab 19, page 102, and it'll be on page 104, 14, paragraph 14. At the same meeting, I was shown a copy of the master sales agreement. That document provides, from my recollection of it, that the sale of the units from Limestone House and Index Tower from Union Properties to Emirates NBD is subject to any leases in place. The rental will be split pro rata. The document refers to the list of the leased units, the Excel spreadsheet. Then 15, the rental checks for the 2 units were sent by Union Properties. condition.
But he's saying that the master sales agreement refers to the Excel spreadsheet?
Well, yes, sir. That's Mr. Naki's
Yeah.
recollection of what he saw, admittedly across the table, sir.
Well,
So,
actually that's not hearsay.
no, sir.
It's not hearsay. He actually witnessed it with his own eyes. So it doesn't matter. Go
That's
on.
a good point, sir. His recollection is about to get tested, I have to say. I was at the same meeting, sir, but I didn't see it. So I was at the other end of the table, so I really don't know what it says.
Yeah, go on.
Thank you. 13. The appellant says that the letter of acceptance dated 26 December 2011 created a concluded agreement for the sale of at least the 25 commercial units described as limestone retail. And that Excel spreadsheet is headed up limestone retail. So it's only purporting to deal with those particular units.
For the moment, I think you can take it that at least on the face of Mr. Carnell's arguments and citation of the relevant provisions from the real property law, would not necessarily help your client. I mean, it's part of your factual narrative, but
Sure.
don't spend too much time on it.
Keep moving. You're quite
because
right, sir.
I think you're going to have to end up developing some other
Argument. I'm fully with you, sir. Now, the appellant says that the letter of acceptance dated the 26th of December 2011 created a concluded agreement.
Yeah, that's a legal argument. So let's not go there, because it's quite clear that your client's letter was an invitation to offer. They made an offer, and subsequently it was all subject to contract. So, for the moment, I wouldn't suggest that you spend a lot of time trying to develop that part of it. I think what we want really not to know are the facts, and then we can make a conclusion.
Thank you, sir. Could I just pose this proposition, and that is, sir, that whilst I accept that at an interlocutory stage, and more so even on an interlocutory appeal, difficult matters of disputed evidence shouldn't really be dealt with by the court. The court faces an obvious burden in dealing with matters where they don't in fact, have the witnesses in front of them and have the contested evidence. Fully accept that. When it comes to issues of law, sir, particularly this court, I enjoin you to, in fact, take the opposite approach and determine them. Where these matters of law are able to be determined, well, they should be.
No, what I'm saying is we'll get to the law. Let's deal with the law
Thank you,
in
sir.
one part of it. Don't try and argue your legal points as you go along.
Very well, sir. Now I understand you. Thank you. 14. The appellant contends that the respondent agreed to purchase the units subject to lease. It further asserts that after the sale, in consistence with its acceptance of the lease, the respondent gave its consent to the Registrar of Companies for the issue of a trade licence, and subsequently to the Registrar of Real Property for registration of the lease.
See, all of this is much more important for us to know.
Thank you, sir.
And presumably you're going to show us what documentary evidence you have.
Yes, I will, sir. It also attempted to bank the rent cheques which had been written by the appellant and given to Union Properties, then subsequently passed to the respondent.
I've seen the
Seen the
checks,
checks,
but I haven't seen the evidence of the banking. So
Thank you, sir.
Show us when
Yes.
you get to it.
The respondent has, at least since the 30th of April 2012, denied that there was a binding lease in favour of the appellant. And that probably is an important document, sir. If we go to Volume 2, Tab 21, page 211. Yes. My reference is wrong there. It should be 212. Thank you. And 21.
Can you remind us who is Ayman Okasha?
He was the manager for Union Properties in charge of that. He's the leasing manager, I understand it, for Union Properties in charge of leasing the units.
Right.
And his name will come up in subsequent correspondence as well. He was Union Properties person in charge.
But this is a letter from the respondent to UNM Properties.
That's right. And it wasn't in fact disclosed to us until last year, sir. So we were not a recipient of this letter, but that appears, from my understanding of the evidence, to be the first time that Union Properties said, we don't accept this letter.
You see, what interests me is points 2 and 4. No, it's not 2 and 4. Points 1 and 3, sorry. That's where the respondent, in unequivocal terms, say that Union Properties made a representation to them at the time of the handover that the units were vacant, and that Union Properties did not disclose the agreement with your clients.
Well,
so, as you go through, you might want to point me to evidence,
yes,
either actual or potential, that those two statements are not correct.
well, with respect, sir, I believe I already have, and that is the Excel spreadsheet disposes of both of them, because it says leased, and so it can't be vacant. We can be vacant and leased, but the point that matters is leased.
They've always been vacant.
Yes.
So it's a question of committed to a lease. Yeah.
Yeah. It's leasing that matters. Possibly they did tell them.
So maybe one is how should I put it? A statement that is perhaps ingenuous.
Yes.
Or rather disingenuous. Sorry. Literally correct, but maybe not of that great legal significance.
Exactly.
But 3 is,
Well,
although, I mean, reading it broadly, it might be suggested that that is a representation that there was a positive representation by Union Properties. These properties are not leased to anyone. That one possible reading of it.
Plus, the agreements between them provided for due diligence. So if one really delves into it, whose responsibility was it to sort it out?
Now, we're talking about an area of something like 30,000 square feet. If it's, I heard 2,930 square meters, right?
Yes.
So it's a very large area. Is it like on the? You said that it comes out into the plaza or something area.
Yes, sir. Indeed, when I walk, for example, from here to the Ritz-Carlton Hotel, I walk out these doors, out through the double doors, up the steps, or one can even take the elevator and escalator, reaches the same point. You walk across a courtyard where there's sometimes performances or something going on. You're walking above what's going to be the boulevard and is full of construction now, across a little bridge. And then you're on that plaza level. And then to go into the Ritz-Carlton, you take the first door or the second door on the right, or even go into an upper courtyard there.
Go past the Ritz-Carlton.
Go past.
Yeah.
And you'll then come on your right, you'll drop into that courtyard bar that's down below, accessible from the street level lobby of the Ritz-Carlton. Go past that on your right, and then turn right, and you're there in another sort of courtyardy area, which is absolutely empty now.
So on a walk around, it's absolutely impossible not to miss it.
Oh, absolutely, sir.
The buyer should be asking,
Yes.
and what's happening to this space?
And indeed, there is a plan which I'll direct.
Okay.
Just ask my assistant, she'll tell me where that plan is.
Okay, carry on in the meantime.
And those two units are the ones closest to the hotel. When one emerges up from the basement bar, if one likes, up the stairs and onto that level.
No, I just wanted to be
right
clear
there.
in my mind that it was not the sort of unit that could be overlooked in an
Very
inventory of retail units.
So that takes me, I think, to just about to get to the points I think that Sir Justice Cook is that I was on 15, so it has denied that there was a binding lease. It has asserted this by the particulars of defence and by letters dated 9 August and 18 September. And it might be of some benefit to go perhaps to the letters, because they really do set out the case, and indeed the letter dated 9 August is particularly pithy, because by that letter the respondent introduced those letters dated 18 and 26 December 2011, the letter of offer and counter offer. So if we could just briefly go to that.
This is Taylor Wessing's letter.
Yes, it is, sir.
Yes, which paragraph?
That's tab 15, volume 1, page 32.
Sorry, did you?
Sorry, my apologies. Tab
Tab 32.
I'm completely losing myself, sorry, sir. It's exactly, thank you, sir. Volume 1, tab 32, page 160. And this is, I think, the best encapsulation of the respondent's case. Not one that they've repeat, but
Paragraphs are you drawing our attention to?
well, probably 4, sir. Furthermore, as the lease was not registered with the DIFC,
Yeah, but this is a matter of law.
matter of law. In light of the SPAs, well, the difficulty with that, sir, is that it wasn't just the SPAs, it was the master sales agreement as well, and indeed the Excel spreadsheet.
Which paragraph you know?
At 5, sir.
5.
It says, accordingly, in light of the SPAs and the applicable law, it's therefore irrelevant whether UP gave notice of the unregistered lease prior to the sale. In any case, it's denied the EMB UP gave notice of the unregistered lease. Following exchange of documents between VB and EMB, there's not been any documentary evidence submitted to the court that UP notified ENDB of the unregistered lease prior to the sale. Well, that, with respect, sir, is incorrect, because as we've seen, the respondents were themselves in possession of the documents which had disclosed the existence of the lease, namely the master sales agreement in the Excel spreadsheet, it now emerges for the first time this morning that they may have in fact lost those documents, which is perhaps an explanation for everything that has gone on. But as a statement of law and fact, it's plainly incorrect. They had been notified of the existence of the leases.
What are we to make of paragraph 9?
Well, what you are to make of that, sir, is that is a post-contractual affirmation of contract.
A post-contractual affirmation of a contract. Affirmation to whom? From the respondent to Union Properties, or from the respondent to your clients? While you're thinking about it, just answer me a factual question. Your clients were or were not aware that there was an attempt to bank in the checks?
He went to a meeting later. I'm pretty sure it's dealt with in the evidence, sir, and I'll find it.
What they're saying is that they bought the units, presumably after completion. Then UP sent to the respondent Vegie Bar's rental checks. And it says which checks were in any event dishonored. Presumably it was dishonored upon presentation by the Emirates Bank.
Exactly, sir. I'll come to that.
Yeah, okay.
What had happened was that the cheques had been written to Union Properties. Okay. Then there were the delays. The cheques had been written to Union Properties upon the signing of the lease, the original lease back in...
last quarter
2010, that's right.
2011.
And then there was obvious delays in getting the property ready for occupation. So there was a subsequent agreement between the appellant and Union Properties to put the cheques or the lease on hold, right, and the cheques on hold. So what happened after that is that the appellant just used money for something else, and the account didn't have the funds in it. Cheques.
But how did Emirates Banks present checks which was made out to Union Properties?
They've been by assignment, sir. I don't know how they did it, but they're a bank. You and I might not manage that, sir, but they did.
Presumably they're endorsed, that's all.
Yes.
Endorsed checks presented to your bank.
Well, it is
One assumes.
It's a peculiarity of life in the Emirates that the simple endorsement of cheques, which I've always done all my life, is not generally acceptable here. But if you're a bank, perhaps the situation is different.
No, but...
Well, it is an oddity, isn't it?
Yes, sir.
It's quite rare to have endorsed, because most checks are pre-marked already, non-negotiable. So the original owner has drawer has to go back and open up the check again, and then...
One could infer that perhaps they had a peek
that's
into
why I
bank
wanted to
accounts
see
or-
what evidence you had of this.
My Lord, if it assists, you might want to turn to pages 214 to 216 in Bundle 2.
Bundle 2 now you're talking about.
Yes, so Mr.
214 to 216.
Mr. Bowden won't have to infer anything, he can look at the chart.
I was getting to that, but let's go there.
I can't read the Arabic, but is the payee, is there an endorsement that it's or bearer or order? Because on the face of it, it looks like an uncrossed check. But anyway, the reason given is dormant account, but do we see who actually presented the check?
Well, no, we don't, but the letter from Taylor Wessing answers that question, that it doesn't say who presented the cheque, but the letter, and indeed your Lordship put your finger on it at paragraph 9, that is the evidence of that. ENDB instructs us that following the purchase of the units, the rental cheques which had previously been received from VB, which cheques were in any event dishonoured.
Well, let's see. What is the date of the...
The date of the banking of the cheques, sir, is...
I thought these checks... Oh, they were post-dated, were they?
Yes, sir. And the date of the banking, you see the stamp there, sir, with the writing on it.
28th of August and the 2nd of February.
Exactly. It's actually, I think, the 2nd of September, sir. That's right.
Yeah. No, that is
The cheques were written out to coincide with the rent being due. They were passed over subsequent to the agreement. In April, by the letter that we looked at tab 22, the 30 April letter of 2012, they denied, sorry, tab 21, they denied that they were responsible for the lease, but subsequent to that, they committed what we say is an act of affirmation by banking the cheques. And the fact that there was no money in the bank account, which was by agreement with Union Properties, got documentary evidence of that, is neither here nor there, because their intention was to affirm the contract.
It takes effect as some form of bearer check, pay against this check, Union Properties or bearer. So the bank could just...
Yeah, if it's a bearer check, then of course, yeah. Go on.
Oh, and indeed, sir, that my assistants very kindly pointed out to me something very important about the documents. If we go, say, to page 215...
Sorry, of the volume 2?
Yes, same cheques, just looking at the looking at the bank stamp on it. Okay, it says drawn on, and then so that it's slightly obscured. The top half of it has been cut off by the placement of the cheque over the stamp here, but that word is drawn on.
Yeah.
ENDB UP Tower Branch.
Yeah. Well,
So
you can see that at the top of the check anyway.
exactly, and if we go over to page 216, it's very clear. So they took it to their own branch and banked it.
Yeah. Okay, go on.
That takes us to, I hope, the nutty point. Does your Lordship intend to take a break at 11:30? Is that?
Are you happy to carry on? Let's carry on.
Carry on.
Unless you...
Yeah, no, not at all, sir. It's just that I had meant to bring copies, complete copies of the relevant legislation, the law of real property.
I've got a copy of the complete act here.
Oh, and that was another error of mine, I apologise. 16. There are two legislative gateways through which the respondent could have become bound by the lease. If the lease were registered with the Registrar of Real Property under Article 55 of the DIFC Real Law of Real Property, that would be conclusive notice to the purchaser. is not known whether registration did in fact occur, hence the application for document production against the Registrar of Real Property.
But who would register the lease? Normally the lessee.
No, actually, it's the responsibility
It's normally
That's the lessor's responsibility under the law of real property.
Sorry?
It's the lessor's responsibility under the law of real property to register the lease. In fact, sir, there's a fine for not doing so.
You want to show that to us?
Yes, I do, sir.
Article 54, isn't it?
Indeed.
54 sub 2.
And it's the subsequent amendment to the law of real property. So there was the 2011 amendment, which also slightly amended that section and brought in and changed the law on it. So yes, it is the responsibility of the lessor to register the lease. And the lessee has a right and damages against the lessor for any consequences of the lessor failing to do that.
Where is that?
That's in the amended sections.
Did either party use solicitors for this transaction?
No, no, sir. It doesn't appear that the
Your client didn't have a lawyer acting?
No, he didn't. No, he did not have a lawyer acting. And all of the documents that I've seen are direct. The letters and emails are all direct between Mr. Al-Khalili and Mr. Ayman himself.
Yep, go on.
Thank you, sir. So that's the first legislative gateway. But there's a very important document, sir, and that's at footnote 17, which is difficult to explain, but we'll do our best. And footnote 17, and that is on 28 May 2012, again, subsequent to the sale and purchase of the units, there was an attempt by Mr. Al-Khalili to register the lease. And he says, sir, that that was done I can take your lordships to volume 2, page 213 at tab 22. I could have permission, sir, for my assistance.
Sorry, I thought you were going to refer us to the witness statement of...
I'll take you to the document first, if I may, sir. My assistant, Miss Al-Samsam's not a lawyer, but I'm wondering if she might be permitted to sit beside me at the bench here, so she has a mastery.
Yes, of course.
She has a mastery of the documents, which I don't. I know the documents, but
so
where they are.
Can you give us the page reference for the document you want us to look at now? Volume 2.
Yes, sir. It's volume 2, page 213. Now this is a very interesting document, sir, because it's post dates the agreement for sale and purchase, and it is a receipt from the Registrar of Real Property, which deals with an attempt to register the lease. And that application just disappeared. It was never rejected. It was never accepted. It just vanished with no more said about it. And all attempts to find out what happened have been fruitless. And it may be, sir, that Your Honours, Mr. Chief Justice's forensic mind indicated why the problem may have arisen. And indeed, sir, it was also referred to in the letter from Taylor Wessing dated the 9th of August last year. But if we just go back to one tab from volume 2, tab 22 to volume 2, tab 21, at page 212, that was a letter we were looking at earlier, and point 2, there's a signed agreement between Ritz-Carlton and UP, where shops offering food and beverage are not allowed to operate. So it may be that subsequent to the sale, the first occurring event was the lease, then there was the sale, then, sir, there was the strata title plan, to which you referred to earlier, sir, and that, it appears, may have stopped the offering of food and beverage in this space. And indeed, my learned friend seems to confirm that in the letter dated the 9th of August. So, only a few days after this letter was written, and it was never disclosed to my client, sir, until the statement of defence was filed in March last year. Unbeknownst to that, my client went, he says, on instructions from the Registrar of Companies to register the lease. He paid the money, he put in the lease for registration, he obtained a receipt, and he's heard nothing since. But he hasn't obtained a refund either, so his application is no doubt pending. And he, sir, explains that in his witness statement, the third witness statement of Mr. Al-Khalili in paragraph 20, which is in volume 1, tab 17, at page 90.
You don't have a timeline. You say that during the 2012 renewal of the Vegie bar trade license, we were informed by the ROC office that we needed to obtain the landlord's consent. What part of 2012 was that?
The trade licenses, they get renewed in March of every year, sir. And I understand that they were a bit late that year. They were running late. So it was definitely in that exact period. So the license, and that's at volume 1, tab 1, sorry, volume 2, tab 1, page 11 is the license, the commercial license.
When does it expire?
14th of March, annually. If we're looking at the exact one, sir, it's on volume 2, page 14, at down the left there, and the expiry date was the 14th of March 2012. So what Mr. Al-Khalali's evidence of that is that we put in for the trade licence, as we usually did. The Registrar of Companies contacted us, said, you need to register your lease. He said, oh gosh, okay, I'll do that. He was told that you need your landlord's permission. He was advised to contact Mrs. Melanie Fernandez, an employee of the respondent. He sent his erstwhile employee out there to pick up the letter when he was told it was ready. The employee did that. He brought it back to the DIFC. He put it into the registry, and interestingly, sir, he said that he put it on, that he believes, and he's casting his mind back, sir, but he believes, and I've interviewed both Mr. Al-Khalali and the employee about this, and they both say that they were using what's called the portal at the time. And they say, well, we believe, but we couldn't say hand on heart, that it was also put in via the portal. But they cannot.
What was put in via the portal?
The letter that they received from the landlord, signed by Melanie Fernandez. So just to go through that time sequence again. 1, registration of the commercial licence had expired in mid-March. 2, they were slightly late with their renewal. 3, they got it in late March, early April. 4, after they had submitted to the Registrar of Companies their application for the commercial licence, they were advised, well, you don't seem to have a registered lease, you should do something about that, and you need your landlord's permission. 6, they contacted the landlord, who was the agent representative was Melanie Fernandez, asked her for a letter. She said fine. It took a while, but Mr. Al-Khalali received advice that the letter was ready. He sent his employee out there to pick it up. The employee says, yes, I picked it up and I brought it back to the Registrar of Companies and I handed it in. He says, in addition to that, I believe that I put it on the portal, which should provide a permanent record, sir. 6, we haven't been able to access the portal. Doesn't seem to be there. And 7, sir, and I was going to come to it later, but we could deal with it now, is we've had quite extensive correspondence with the Registrar of Companies, really an attempt to resolve the application or the appeal against him. And they have told me informally, and I had hoped it would be here by today, sir, that they don't have that letter either, which have, last I heard, which was only a matter of days ago, were going back to look more, or look harder, or look further. But so that whole sequence of events here is somewhat shrouded in mystery. But
looking for, in this affidavit or witness statement, at paragraph 20, this is already in the context of active litigation between your clients and the respondents.
Sure.
And you know that their position is they were never told about your client's existence as a tenant. So, first of all, in this oral account you've just given us, you talk about an employee of Vegie who has not given us a witness statement on something which is pretty critical from your point of view. Second, you say we contacted Melanie Fernandez, an employee of ENBDP, and then she got back to us and indicated that the letter was ready. So that's the only evidence that we have on record that at the material time, your clients were in direct contact with the bank or the property company and had effectively been recognized as a tenant, and the one person who can give first-hand evidence of it hasn't given us any evidence. And secondly, you would have expected an explanation of why, when you contacted Melanie Fernandez, she would have known who you were and why she should help you. All of this is not explained.
Can I answer this, sir? That witness statement, what was put in the context of an application for discovery against the registrar. Okay, so it doesn't purport to be conclusive of that issue, and in drafting it, sir, the most we can really say on that point is that, well, we made an application for the lease to be registered. We don't know what happened to it, and we had these other communications. So I'm not putting it forward to this court, sir, as conclusive proof of registration.
No, but it's conclusive evidence that what was said in Taylor Wessing's letter was incorrect, that they didn't know who you were, they never told about your client's existence as a tenant in the building. Anyway, well, let me just...
Well, yeah, I do appreciate the point, sir, and I'm not saying that I didn't consider it at all. What was going through my explanation for that, sir, is that I didn't feel that on the documentation that we had, and even after interviewing the witness, Mr. Gosen, who's discussed at paragraph 21, that we could push this point forward as conclusive. And when it comes to countering what Taylor Wessing said in the
letter... What you mean by conclusive? You keep on talking about the word conclusive. Is that a term of art in this context? In other words, is it a statutory term?
No, an evidential term, sir. Evidentially. So my assessment of the evidence that we've just been looking at the time of producing these documents was that it did not establish the requisite standard of proof that there was registration. And the purpose for putting the evidence before the court in this witness statement was in support of an application for document production against the Registrar of Real Property.
But right now we want to know the facts. We're not interested so much in the context. But this was your one time that you referred to some actual hard evidence that they knew who Vegie Bar was. And it would have assisted us, or it would assist us now, to know more about the context. And the second thing is that you said that it is the lessor's duty to register the lease. Your client didn't seem to have followed up at all to find out whether or not the lease had been registered. And if you say that it is the lessor who has to register and there's no provision for a lessee to register, then what was your client doing, running down to the registry of real property to try and register? Wouldn't he have been thrown out by the land registry? Well, all of this is not explained.
Can you help us as to what page 217 at tab 25 shows?
Indeed, sir.
I understand for the index, that's an internal message between one member of UP to another.
That's correct.
And that talks about this very subject, registration of the unit and the lease. What are we supposed to make of that?
That's an internal document, sir. So it doesn't...
But what does it say? Is it saying the lease has been registered, or is it not?
No, I don't believe that it says the lease.
I think, as I read it earlier, before this hearing, what it was saying is somebody at the top of the management chain was giving instructions for the lease to be registered. And if I recall, I think somewhere in the Taylor-Wessing correspondence, there is some, when I think actually Union Properties and the respondent engaged directly, arising from, I think, your firm's letter addressed to both parties. Then, of course, Union Properties started to say, look, you've got to get us out of this hole. And Taylor-Wessing is saying, you never told us now, and as we see it, you are now busy covering your tracks by trying to do all of these exercises in registration. That's why the timeline becomes a little important, and I haven't tracked exactly, when things happen. So, somebody had the ball and somebody dropped the ball. The only question was who had the ball at the time that it was dropped, and then the consequences of that. But of course, you step back a moment and say, there are certain equitable considerations, but it's very hard to, the whole point of this legislation was to remove as far as possible equitable considerations which affect the public awareness of who is the owner and who is a lessee on the register, which is why the register normally is considered to be conclusive. And the legislation allows for some exception in undefined provision about equitable considerations arising from the registered owner's conduct. So the conduct surely must have some bearing towards your client, which is why the evidence of what happened between your client and Mr. Hanel's client is quite important if you're going to develop that line.
Well, I've given my explanation for why I didn't go into huge forensic detail on that. That's a judgment call made by me. I don't want that to be a wrong one. But
we'll not bother with the forensic discussion anymore. Why don't we take you back to where you were, and you want to develop this further now?
To answer Your Honour's point as to the interplay between the two, I do say that Excel spreadsheet, I don't know how many times I'm going to mention that, is conclusive of that point. And there's no real need to go diving into other points.
It's conclusive of a fact. That may not be conclusive of any legal outcome, right?
It's conclusive of a fact, yes. Yeah. Yes. It is conclusive of a fact. And that fact is knowledge at the relevant time. And but of course, sir, the DIFC law requires more than knowledge.
But you're going back into deep common law, because what you are trying to do is resurrect an old common law doctrine that says if a buyer looks at a property, he sees someone in occupation, he's fixed with constructive notice, it's his duty to go and search, to find out what that person is there for, and if that person actually has legal rights and he's bound by those legal rights. And that's what the legislation seeks to avoid.
I'd like to put my case a bit higher than that, sir. I'm from New Zealand, sir.
Right. Let me just explain to you why I draw that analogy. Is because the best that you can say is that you were given this spreadsheet, and the spreadsheet tells you these 2 units are leased. That's all. It doesn't tell you who it was leased to. It doesn't tell you the term, the rental, and so on. So you are trying to say, well, then with that, there was a duty on them to go and inquire. And Mr. Carnell correctly points out a number of provisions in the legislation which indicate that that was not intended to be the way that the law of real property was going to operate in this zone. But let's save that for a little bit later. Let me just sort of throw this thought out for you at this moment. As Mr. Carnell points out, you are now at this late stage raising this section of the Real Property Act, which suggests that you can still rely on some equitable doctrine to secure a client's interest. The equitable doctrine may lie in a number of factors, so you have to now give us some law in support of what kind of equitable factors would compel a court to recognize that. But what you haven't explored, it seems to me, is this. A lot of things you say, or you assert, and at the moment it's just assertions, indicate to you, or in your submission, indicate that they knew about your client's interest in the premises. But Mr. Carnell is taking a very hard line. It doesn't matter whether we knew, we're not bound, because we don't see anything on the register, and we are entitled to take advantage of that. But if the facts that you allege indicate that not only did they know about your client's presence or your client's potential interest in the property, but that your client actually was certainly, to put it at its lowest, interested and desirous of being a tenant, and they knew what the terms of the tenancy were, and that they, you see, I kept on asking just now, you talked about a firm affirmation, and I asked you the question which you didn't answer, affirm to whom? And if they, let's take this hypothetical scenario, that Mr. Carnell's argument is that even if you saw your chaps doling out vegetables by the bucketful on a sunny day, and they walk by and say, well, we see this fellow, but his interest isn't on the register, we don't have to worry about him. But if they came and said to the manager, how much money are you making, and what are you doing for the business of the plaza as a whole, and they get interested in your client and says, well, we understand that you had a lease with the last owner, even though it's not binding on us, would you be interested in staying on? And they strike a deal. Then there is a direct relationship between your client and their clients, if the evidence were to support that. And that would be a contractual argument, not an equitable argument. So far it's not there.
I completely agree with that analysis, Sue. And that is indeed the analysis that I hope
that
goes
is why I think we're a bit concerned to know, as far as possible, from what we've got here, what kind of facts are thrown up. That's why I'm telling you, don't spend too much time on the existing law as it is.
Grateful. And just to finish that point, to resolve that issue in relation to the registration of the lease seemed to me, at the point of making these documents, to be a little difficult. So, therefore, that's the purpose of bringing that forward. Give me the application, grant my application for an order against the real registrar of real property, and we will know the answer to these things. Grant my application for the order against the registrar of companies, and we will know the answer to these things. So the answer's what I'm saying, sir, is it's a credible narrative that is put forward. We did not wish to over-egg our pudding, sir, and we've been careful not to do so. But there is a credible narrative there. If we get these applications, we can resolve all of these issues. But instead, what we got was not that. We've heard this morning that anyway, we were told that, well, you should go to the respondent first for it, but Mr. Carnell has admitted this morning, well, we've lost the documents anyway.
With respect, I didn't say we'd lost it.
After 6 years and 18 months of this litigation, they are unable to find them.
Just so that we don't remind ourselves, there are the two documents that Ms. Ultra brought with her. And in addition to those, what other documents? You then want the documents, the Registrar of Companies file and the Registrar of Real Properties file. And I think you said that at the time of the application, there was not any objection in principle by Mr. Carnell, other than it was premature.
I don't want to put words into
I'm sure Mr. Carnell will confirm
that was
later,
his,
but-
that was his argument. It's premature. I have to confess, sir, I don't understand that argument. Because I don't see that there's any primacy that you shall go to the other party first and exhaust all the avenues there when we fully know in relation to the documents which Ms Bushra has got at the back of the court that they don't have them, or we've found that out today, and in relation to the documents that are at the Company's Office, there's no reason to believe that they would have many of them. They might have the letter from Miss Melanie Fernandez, they should have, but it doesn't sound like the record keeping is very good. And thirdly, there's nothing to say that they would have the internal documents from the Registrar of Real Property, although they might.
But there's also nothing to say that the documents you're looking for are documents which they would rely on, because that's what standard production is about. Yes. It's not about all documents which are relevant. Don't forget, this Part 28 is not based on the English CPR. It's based on the IBA rules. So if you don't rely on it, you don't have to disclose it. Then you are subject to specific reduction on request. So, we are where we are now. That's what I'm saying. Yeah. Let's try and see what's going to help us. I think the last thing we want to do is to send this case back down again for another round of document production, at least of the critical documents, which could shed a lot of light on where parties stand in respect to each other.
Just coming back to your point, sir, and if we do get a break, I will produce this, sir.
You'll get a break at lunch.
There is a letter which is CC'd to the very same Melanie Fernandez, and that it has gone between the parties, sir, in relation.
Right. Is it in our bundle?
No, it's not, and that would be.
So you will have to introduce another new document.
Yes, sir, and I'll have to get a printout of it. It's on my assistant's piece.
Maybe
it's been disclosed, sir.
Huh?
It's a disclosed document. It is in fact on the court file on document production bundles, but I'll get it and bring it forward if I may, sir. But what that says...
But it is a document in the record, it's just that it's not in the bundle. Okay, then you can bring it back later.
I'm casting my mind back to early last year when this went out, so I'll have to satisfy myself of that, but that's what I'm told by my very intelligent assistant, sir.
No, if it's in the record, you can always bring it back.
And it says, it's from Mr. Eamon Okasha, who's the leasing manager for Union Properties, to Mohammed Sunala, who is a manager of his, I understand, at Union Properties, very high up, I think the general manager, and Melanie Fernandez, who was Mr. Okasha's opposite number over at Emirates NBD. It says, dear all, dated March 3, so predating the 30 April letter that we have, predating, sir, the letter and predating the application for registration. Dear all,
sorry to butt in, but I think you'll find it's at page 255 of volume 2, along with the response.
That makes the task a lot easier. Thank you very much.
This is the one you were looking for, is it, Mr. Loudon?
255 at the bottom. Sorry. They're all. And there is copies, both of those letters are copied to Melanie Fernandez.
The top one is from Melanie Fernandez.
Mr. Bowden, when was your firm's letter to both parties that raised the issue of your client's interest?
June 2015.
2015. Okay. So, when was the date of the sale and purchase agreements? 12, isn't it? 2012?
Yes, sir. The sale and purchase agreements are at tabs 17.
Because these documents at page 255, they are 2013. So whatever legal rights between
Yes.
Union Properties and the respondent
That's
would
right.
have crystallized already. And then what we see is some disagreement between the Emirates side and the Vegie bar side about the position of Vegie bar. Sorry, between Union Properties and Emirates arguing about Vegie bar.
In fact, you're quite right, sir.
Which is inconclusive because we don't have the ultimate end of that correspondence. Well, except looking at page 256, if that is the last word on the subject for Ms. Fernandez, then Ms. Shi is saying that as far as we're concerned, we don't recognize Vegie bar, and they've got to come and sign a new contract with us.
That's correct, sir. So at that point in time, their attitude had hardened up.
But at that time, as far as Vegie bar was concerned, it was all quiet on the Western Front. Your client was not aware of anything that was being argued between Union Properties and Emirates.
At that stage, sir, it's dealt with in his first witness statement. No, he was just turning up there and saying, how are we going with the... When can I take occupation?
What, because the building, there was still some works to be done, or?
Yes, by 2013, sir, he was starting to form the view that it was taking a long time. He deposes, sir, that he'd had a lot of trouble getting hold of anyone at Emirates National Bank, and it was not until a subsequent meeting that he was told it's all over.
But they were buying a completed building, were they not? Unless
Yes,
they were going
yes.
to renovate it seriously.
Completed.
It was
Yeah.
completed.
No fit out done. No fit out. So that the...
Oh, it was a vacant building, is it?
Yes, I do invite your lordships to have a look at it. You can see in the window, and it's typical of a unfitted out space, i.e. the pipes are still running through the ceiling, the floor is concrete and still got kind of rubble on it. There seems to be a trailer parked in there that's nothing to do with my client.
And your client says he sent money to UP for them to do the outfitting. Is that right?
And that's right.
It also appears from page 257 that your client did in fact approach
That's right.
the respondents with a view to having a new lease directly from them, because there's a letter back referring to it as between the respondents and UP.
At that stage, he's just trying to assert his rights, not upset anybody too much. Believed that the situation would resolve itself as things do tend to over time, and everyone sits down and something gets sorted out and off we go.
Move on, Mr.
Yes, thank you, sir. I got through to 16A, sir, and now I think we come to the interesting part of Article 31H of the Law of Real Property. And we say, sir, that Article 31H of the DIFC Law of Property is the other gateway, other than registration. Okay, I don't assert that we've proven on an interlocutory basis, at least, that we've got a binding lease, but I do assert that we have got a binding lease under Article 31H, but we're now at an appeal, sir, again in respect of an interlocutory order against my client, sir, in respect of the security of the costs. But in appealing that point, sir, I am making the point that we would have grounds to make an application for immediate judgment on these points, because I say I'll avoid the word conclusives, but it is very strong, or in terms of 25110, like certain or almost certain to succeed on these points. Article 31H provides that the owner will be bound by a prior unregistered interest in the land if it creates an equitable obligation binding the registered owner as a result of the registered owner's conduct. And over to 17, sir. (17.1). Submit that the application of 31H can arise in two relevant ways, and the second has got several sub-ways. 1. The registered owner simply buying the underlying units and creating an equitable transfer of the unregistered lease by contract. The DIFC law does not recognise adverse possession, and even actual or constructive notice of a prior unregistered interest is insufficient to bind a purchaser. Now, I understand, Chief Justice, that you have an Australian law background where, of course, the Torrens system was originated from the land registry in Melbourne. And
the New Zealanders might have some dispute about that. Never mind, go on.
I think he was in New Zealand. That's correct, sir. But I've been involved in many cases, several large cases in New Zealand on indefeasibility, the fraud exception, and it's a fact that in New Zealand, the seminal case in New Zealand was in the west coast of the South Island, where somebody purchased the land, and there was tracks across it to a campsite on a separate parcel of land on the other side of it. It was held that the existence of those tracks, motor vehicle tracks running across a grass paddock, must have put the purchaser, who had admittedly inspected the land, on notice that there was an unregistered easement in favour of the campsite on the land beyond. So that's the law where I come from, sir. That and using the vegetable barrow example of yourself, sir, if you become aware in objective circumstances that this is going on, well that's enough. Here, clearly, although I understand that the law of real property in the DIFC was in fact drafted by Australians, or had some input from Australians, it seeks to close that gap, as the Chief Justice correctly pointed out. But it has left it available for these equitable measures. So it's quite different that the constructive notice of prior unregistered interest is insufficient, but I say, and it's halfway through 21, sir, 17.1, however, intentionally buying the underlying units expressly subject to lease goes well beyond the threshold of actual constructive notice set out in Article 30, brackets 2, brackets A of the Real Property Law, and engages 31H. And I put as my authority for that, sir, the case of Walsh.
How does it go beyond actual notice? Buying with actual notice? But
No, sir, you've contracted for it. So you say, it's part of the consideration. So I'm buying it, and that's why the two buildings perhaps becomes important, because Index House was a residential tower, and that's full of residential, or it's a leased tower. So the leases are actually a very valuable and important part of what you're buying. I'm sure you knows that building values are set often in relation, or it's one of the indicia that the valuer takes into account is the value of the
what
leases.
you actually mean is not buying the underlying units subject to the lease, but actually buying the assignment of the lease. That's what you really mean.
That is what I really mean, sir. You're quite right. That's exactly what I mean. And there's the instruction to send over the cheques and dealing with that point in the letter of the 26th of December, the counter offer letter, is really directed straight to that point. Yeah, we want to buy these buildings, and we want those leases as well, and we'll take the pro rata assignment of those cheques, thank you very much, from the date of sale, which is exactly what it says. And that is indeed what they got. And as I understand it, from Mr. Al-Khalali's recollection on his fifth witness statement, fourth and fifth witness statements, that's what the master sales agreement will hopefully tell us. It might be appropriate to look to volume, the accounts bundle. The bundle, it's a thin volume, it's got appellant's bundle of authorities. And just another slight bit of housekeeping. On the outside is an index, but it really would be most helpful if it had one on the inside as well. With the Chief Justice's leave, I'll just hand up if I may. Thank you. They're completely unchanged, but it just makes them. That could be slotted in as the very first page. Same document as on the cover. But
Mr. Bowden, if you would sit down for a moment.
Thank you.
You know, we are considering this case purely from the point of view of the overriding objective and how, as I said many times before, we are where we are. Frankly, we shouldn't be where we are. And we're trying to see how we can bring some order and efficiency to the whole process. And what we are considering at the moment is asking Mr. Bowden to stop for a moment, because the way we see it, we think that at this stage, let's get everything out on the table that Mr. Bowden wants. He takes it back, he looks at it, reconsiders his case. Hopefully at that point there will be more or less equality of information on both sides. Both are very senior and competent counsel. Hopefully you will look at the objective facts. I mean, there's not a lot of facts in dispute, and each of you can then advise your clients where they stand, and possibly if there's serious disagreement on some facts and the case has to turn on a contested action in court, so be it, but we try and clear the path, and clearly Mr. Bowden needs to do some amendment to his pleadings if he's going to get anywhere after looking at the documents. Mr. Carnell still has the option, of course, of saying, even if you amend your pleadings in any way, you still don't have a case, and he's entitled to fight that if he wants. But it may be that with some documents coming out, Mr. Carnell will also want to consider perhaps taking a different course than all-out confrontation in court, which is perhaps disproportionate to the value of the case. I mean, we have actually more questions. I mean, the security for cost issue also, not sure that it's worth arguing. Mr. Carnell quite rightly again points to all the authorities, and Mr. Bowden has a somewhat uphill task on that. But on the other hand, what we wonder is that a somewhat bleak picture is painted in the papers on behalf of Vegie to say that they can't afford to pay, and Mr. Carnell has put down a marker as to there is no reason why they should be in a position that they can't pay. They may have to divert other funds to meet their security requirements. But, I mean, there are ways around it. If Mr. Naki is still continuing to be a reasonably successful businessman, he himself could put up security, and then the problem would be resolved either by procuring a bank guarantee or putting up some other assets as security. You know, these are all things which should be considered by both sides. We think that the interlocutories have somewhat overwhelmed the main path to the end of the road, and so our inclination, subject to allowing Mr. Carnell, of course, to address us on this particular point, is to allow the application for disclosure of whatever documents Mr. Bowden wants from the registry, the two registry concerned. That will take care of the remaining items of the agenda. And then what we are minded to do is to stand down the application for security. You can take it that after parties have looked at the documents that have arisen out of this exercise that Mr. Bowden wants to go through, parties will re-look at their respective cases. As I said, there's not a lot of difficult law. There are some new areas that would be interesting to explore. The court would be quite interested as an academic exercise in judging this case, but we think that it is not actually appropriate in all the circumstances that so much energy should be expended, particularly in time and cost as well, for this case, which might possibly be settled. And if it can't be settled, then there might be more fresh ideas introduced into the appellant side as to how to run their case in a more direct way and not to fight against what seemed to be quite strong points on the respondent side in relation to the case as it is now framed. But if you can't agree on that after looking at the evidence, you may have to come back to us. But we can give you an indication now that we might well be inclined to maintain the security order for costs, even if we give all of the interlocutory reliefs, the disclosure reliefs that are being sought by the appellant. So if I can sum up, what we are feeling at the moment is to grant Mr. Bowden everything that he wants and to further progress the prosecution of his client's case. Of course, the financial consequences we can keep on hold for the time being. Costs will not be resolved right now. But let's see where the case goes. And ideally, if the parties can't review their own attitudes to the case in the light of any new evidence that emerges, then there might be another case management conference to see the case through in a more direct and positive way and get it on for trial as soon as we can. We don't really want to have further interlocutory skirmishes anymore, apart from Mr. Carnell perhaps reviving or asking for the security for costs to be resolved. And if, having seen all of the documents, appellant is firmly convinced that they have a case worth fighting for, then they should start looking for ways and means of providing the security that may well be ordered. See, what again is puzzling us is this is a dispute with actually 3 parties involved, and we're just wondering why union properties have not so far been brought into the picture by either party, because it's going to be relatively expensive for the appellant to, if they lose the case against the Emirates Bank, they will have to come back and take on union properties. I have read some correspondence and I appreciate that there is some cooperation being offered, but at the end of the day, it's a legal situation, and either parties say, well, we have to stand for our rights. I mean, Vegie will say, look, somebody has got to give us relief. We are the injured party in this whole exercise, so somebody's got to give us relief, whether it is specific performance or it is monetary compensation. We have to look to somebody, and at the moment it looks like there's going to be 2 battles, which is going to be a bit complicated. So I think it's time for parties to re-look at their respective strategies. On what we are seeing this morning, and we make no more than an observation, and certainly not a finding, is that the respondent has taken a very forthright position. Mr. Carnell has written on behalf of his client, no doubt on instructions, that they don't know anything about Vegie Bar. It was not disclosed to them. They didn't have any idea that there was a tenant there. But we have seen some correspondence which seems to cast doubt on that. And therefore, their witnesses are likely to come under some kind of questioning on that aspect of it. And once you have a question to doubt the veracity of certain very strong statements made by a party, then that could impact the outcome, particularly if Mr. Bowden runs his argument about the equitable considerations to be taken into account based on the party's conduct. So, Mr. Carnell, would you like to respond to that? I know it's a little bit unfair in the sense that I'm asking you to take on board a new situation that has emerged, but I know that you are never short for words, and will respond.
Thank you.
Sorry, did you want to clarify something, Mr. Bowden?
I didn't want to jump in, but otherwise I might be inviting Mr. Carnell to respond twice, because I did say, sir, that I indicated that I would disclose to the court my recent correspondence with the registrar of the registrar of companies and his office. And I'm just wondering if, prior to making any orders, or indeed prior to my learned friend addressing you, if the court wanted to see those.
Yes. Well, do you want us to look at it, or you actually want to read it out?
I'd be happy for everyone to look at it.
Yes. Why don't we look at it? Which you would take your seat a minute, Mr. Carnell. Let's quickly look at this and see how it affects. Mr. Carnell has not seen this.
No, sir. He hasn't been part of this correspondence. Trying to work it out with the registrar of companies. We've gotten very close to doing so. But
This is just with the registry of companies. Okay, so this is about the trade license, is it?
yes, sir. This all relates to the trade license.
So which is the? I see a lot of letters from you.
Yes, backwards and forwards. Just the last minute follow up, which didn't come to fruition. Then, sir, I think what matters is somewhere in the background you might have seen, bottom of page 2, sir, of the emails, in tab 1, page 2, you see a letter from Mr. Al-Zaruni, the registrar of companies. And you might have seen somewhere along the line, sir, that the registrar had threatened to strike off Vegie Bar, and indeed did do so for a very short time.
Well, I've seen his letter extending the
But he's resolved the matter, sir, and put it back. So, and then, sir, Mr. Al-Zaruni had indicated, and that is at the top of page 4, with regard to your request to having a copy of the company's file. Please note, we're happy to discuss this request.
Sorry, that part I can't find yet.
Tab 1, page 4, sir.
Top of the page, you mean, but doesn't it begin on... Oh, no, it begins at the top of page 4. Yes, okay.
They're backwards printed emails.
But that's the one about your status. What about the evidence? Because if you're struck off, then you won't be here.
We're back, sir. He's restored us to the end of the case, so that's
Right.
no problem.
That's fine. Anything else?
I was just setting out, there's a letter in tab 2 and tab 3 of my letters to the registrar. I had narrowed my search, and the registrar had indicated that he would raise objection to confidential documents on their file. So I don't want to plunge into another dispute, sir, by not disclosing this correspondence to the court, and having the court order the the production of documents which the registrar would regard as confidential, and then come back for another dispute. It would be, maybe what I should do, sir, is fashion an order and put it before the court, which would seek to have the registrar list the documents in his possession and note those in respect of which he claims confidentiality. Because he told me straight out, sir, that I'm not going to give you confidential documents, or documents I consider confidential to me. And I'm sure he made that point, sir.
Yes? Okay.
Thank you.
That's only for the registrar of companies. For the registry of titles?
No.
By registry of
real
property, yeah.
No, he very friendly, but he doesn't really wish to correspond with me, so that's fine.
We will make the order and then see what reaction he makes. I mean, he can always come and
he's
ask
been
us to
served with
modify
everything, and that's accepted, and the correspondence proves accept service of everything. Everybody knows about the proceedings, sir.
Yes, right, Mr. Anil.
Thank you, my lord. Just a few points, because in principle the indications which your lordship has given do have a great ring of common sense about them. From the respondent's point of view, it is not, and it never has been, our wish to become embroiled in a kind of interlocutory miasma, which this case has become, and I think you've put your finger on very, very, very clearly. There are a few points which I raise simply because no doubt you will be able to provide some guidance as to how these should be addressed. The reason for making the application for security for costs in the first place was because the respondent did not want to become dragged into what would no doubt be lengthy and expensive litigation brought by a self-confessed impecunious claimant. The order was made by Judge Shanlun. It may well be that upon reflection the claimant considers that it needs to recalibrate its case, but it will be the case that we will then, unless security is provided, no doubt be back in front of your lordships, essentially on Mr. Bowden's side, asking for the security or the order for security for costs to be overturned. In our case, asking for that order to be affirmed. So,
but at the moment, the stay has been ordered?
Yes. And at the moment, it may well be, I don't know because I don't have instructions, but it may well be that were Mr. Bowden to come back to us saying, well, we've been back to Mr. Naki is proposing to provide the following by way of security, that might well be a way of getting round this particular issue. It is, however, the case that the order was made in September. We say then, we say now, that it was entirely the right order to make. And it is the case that the suggestions which your lordship has made do very much have front and centre that either security is provided as ordered or some acceptable alternative is produced.
So you want us to make that order now or something? I mean, you already have an order, and it's in force.
In the spirit of what your lordship has just said, I don't think I can necessarily ask you to make an order. What I think I can do, adopting the sort of collaborative approach which you've been suggesting, is that you might want to give an indication, perhaps, that really the options open to the claimant are either to comply with the order, to provide an acceptable alternative, or, obviously, if it concludes that its case really is as formidable as it would have you believe, then it might want to restore its appeal. But those are really the three options. And if it's the last of those, then unfortunately the trench war will continue.
And you'll be in the trenches.
Never knowingly shirked them, my lord. That was the first point. In your comments, you to suggest that the claimant and indeed the respondent, should it so consider, should essentially revisit its position. I would just like to draw your attention to one document, which I draw to your attention mainly because it's something that was not raised by the claimant, but does fit into the timeline and does merit very serious consideration in terms of how the sequence of events actually slotted together. We don't have to look at the document if you don't wish, but I do just flag up. It's Bundle 2, page 211. Tab 20. Mr. Ayman.
We have it.
Yes, I was just going to draw your attention particularly to paragraph 2 and to the last line and a half or so beginning while all future checks. And your lordships might also just note the date of this, which is 15th of March 2012, which is after the transaction was apparently concluded. One simply raises this point. If the position were, as the claimant maintains, what on earth were Union Properties doing writing to them in these circumstances? That's a question to which I don't have an answer. There may be an answer, but at the moment that's not something that on which any light has as yet been shed.
Right. Why did they write that last paragraph?
Well, one asks oneself. Perhaps I could put the question this way. On the claimant's case, by this date, the leases of the two units had vested in my clients. Union Properties were off the scene. They had no interest in writing this letter.
Well, you have somewhere in your correspondence, I think, referred to this letter.
Yes.
And said this is some attempt to, how should I put it, to mitigate the situation which had been created when you didn't tell us that there was this tenant, and you're trying to now somehow put in place remedial measures to cover your potential liability to us. I got the impression that was
not quite right, my lord. Bear in mind this.
You know the letter I'm referring to.
I do know the letter you're referring to. But remember, this is a letter from Union Properties to Vegie Bar.
Which you eventually saw.
Which indeed we eventually saw. But
And that was why you made a comment on it.
yes,
Yeah.
but this was eventually, and one wonders what at this point was going on as between Union Properties and the claimant.
But wasn't this more or less contemporaneous with those internal emails that we saw to which Melanie Fernandez was copied?
No, those were a year later.
A year later, okay. Oh yeah, this is 2012,
Yes.
that's right.
Yes, that's why I drew your attention to the date. So,
But I mean, I think we are not getting the complete factual picture because, you know, what if this went to trial, somebody's going to have to tell us what happened when parties were discussing and negotiating and walking around the building and seeing this particular location. And I cannot believe that your clients didn't ask the vendor, Union Properties, what's happening to this particular, have you earmarked this particular property for any tenant or not? So that's something that is a factual thing which you will have to explain in due course. But, you know, no, sorry, just, these letters are, I didn't understand this letter, I must say, when I first read it. But then we've been told that neither side was represented by lawyers, which shows you that some of the letters I've seen written, I think by your clients, show, you know, lack of appreciation of the legal rules that govern transfer of leases. So it is entirely possible that people could have written letters which to them made some business sense, but were inappropriate in the context of the legal situation at the time.
I think in fairness to all parties concerned, I think when Mr. Bowden said neither party was represented by lawyers, he was referring to UP and Vegie Bar. My understanding is that Emirates NBD were represented by their in-house legal department. That is my present understanding. But you make, my lord, if I may say so, you make a very good point, which is that it is unhelpful in the context of interlocutory proceedings for parties to attempt to focus on individual pieces of correspondence divorced from their wider context, and to say, well, this means that I have an unassailable case. That what I said to Jeremy earlier was that we accept that there is an arguable case on both sides. We do make the point that in the face of the issue over registration of the lease, the claimant's case has what we see as being a very significant problem. But that is not a point for now.
But all of that does rather emphasise what the Chief Justice has said. This is a case that has all the possibilities of becoming increasingly expensive, with a third party being joined if the claimant is to receive satisfaction from one source or another. The expense involved in a matter of that kind will be very considerable. If this material is now forthcoming from all sources, everybody can evaluate their own position, take a commercial view about it, and decide what's appropriate. I think the message that has come across to Mr. Brown, if he hasn't got it by now, he ought to, is that he needs a slam dunk point if he's going to avoid having to give security for costs in some shape or form. And unless this new material gives him, as you put it, a slam dunk point where the court is 100% satisfied, or as near as makes no difference, close to that he's going to succeed, he's going to have to produce some security.
I think that's right. I suspect you, like I, feel sorry to have to use a basketball metaphor, but I think it's exactly right in the circumstances. No, I think that's exactly right. Now we are where we are, as His Honour the Chief Justice has quite rightly pointed out. I do just say, for the record, that it has not been any part of the respondent's wish to become involved in a kind of what I call an interlocutory miasma, because we are 12 months and more into these proceedings, and we have yet to get directions. Now, that it may in due course be that reckoning will have to be taken as to who is responsible for that, but I do just put down that marker now. My Lord, I had only, I think, one or two very, very small further points that I just wanted to make. No, in fact, I don't think I need to make those. Save just to ask the question. It's in my experience not uncommon, perhaps more in arbitration than before your Lordship's court, for tribunals to give parties indications as to the course of action which they should then adopt. An unfortunate feature of that is that the parties go away with differing recollections of what they have been directed to do. Is it your Lordship's intention to produce something in the nature of an order or a direction?
Yeah, I think we have to make orders on the applications which are particularly for the third parties, the registrars concerned. They need orders.
Yes.
Are you looking for something more than that in the context of perpetuating the stay on the basis that the party should re-evaluate the position or something? Is that what you're looking for?
I was actually going to ask, my Lord, exactly how that was going to be framed, because at the moment I can't quite.
Which part are you in doubt about?
Well, at the present time there is a stay in place.
Yes.
Now, it is presumably going to be the case that the stay remains in place, but the claimant, save for the orders that you've made in relation to disclosure, and the claimant is, but the parties are directed to go and essentially to go and consider their respective positions.
We will say something about the stay when we make these directions.
Thank you. I think that's really all I need assistance with.
Yeah, I think, again, thinking out loud and subject to discussing it with my colleagues over the break. On the one hand, we will give Mr. Bowden all the orders that he wants, and perhaps Mr. Bowden can actually, in the break, prepare a draft of the order that you would like us to make for the benefit of the two registries in particular, as well as the other orders that you want, so that we'll look at the draft order after lunch. We'll think about what to do about the stay. We'll draft something up, and then we'll put the two together.
Thank you. I did have a very skeletal outline of how I hope the matter could be resolved. I think, one, the summons, the subpoena duces tecum. If Ms. Bushra could simply be invited to leave the documents she has with the registrar, yes, and that would resolve that. Two, in relation to the orders for the registrars, well, I'll of course try and fashion an order which would take into account the comments I've received from the registrars, and narrow and deal with the issue. Three, regarding the stay, well, taking His Lordship Sir Jeremy Cook's view, just expressed that we're really looking for documents from all parties, and I was nearly there in my skeleton, and I just point to 17(2) A, B, and C when I was talking about the way that the right can arise, and that was by the affirmation points, and I'd indicated the affirmations were the trade licence, which we've discussed, the registration of the lease, which we've discussed, and C, any other act of affirmation, the cheques, the trade licence, the lease, the registration of the lease, and the banking of the cheques. Right. I've pointed to those as being three possible sources of an affirmation, right, whether to our client, the other party, or indeed the world. That would, some at least of that would involve documents being provided by the respondent. For example, in discussion, the Chief Justice indicated we need to know what happened between Ms. Fernandez, your client, my client, and the registrar of companies. And my client doesn't have a great deal of evidence about that. That's why we want it. So it may be that the stay should be varied and document production ordered, and specifically in relation to that class of matters. Because those matters are undoubtedly relevant, and if we're really looking at resolving all the disputes between the parties, those would be relevant disputes.
Sorry to jump in there, my lord, but if Mr. Bowden wants disclosure to be ordered, he must provide security.
I didn't hear you so clearly.
If
He's not asking for disclosure as such. He's wanting a limited number of items, and that's the question that might have to be looked at. You might have to think about that over lunch, because if it was simply looking for 2 or 3 documents, that might be one issue. And if it was giving wholesale disclosure, I follow.
Well,
Problem on costs.
I think that's exactly right. If Mr. Bowden could direct his mind to precisely what it is that he is seeking, it may be that he's going to need to go away and take some instructions. But if it's a very tightly focused request, then that is something which I would be strongly advising my client to treat very constructively.
Yes. This really is a case of trying to get some cards on the table,
yes,
so that people can really see where they are.
And at the moment, you see, the issue about costs isn't so critical, because in the context of today's proceedings, he's not asking for any documents from your side. He's only asking from the third. So your client doesn't have to incur any more costs until the documents are produced, and then your clients will look at them. But that's not really a big issue in terms of costs.
Yes, except that Mr. Bowden has just said precisely the opposite, and has said that he would be seeking disclosure in some form, and that does concern me hugely.
Well, that depends on how he's going to frame it, and then if we still maintain the stay, then you always have the ability to lift the stay to the extent necessary.
Indeed, but I think
if there might be smoking guns.
Well, there may well be smoking guns on both sides, my lord. I don't pretend to be able to.
The stay applies to both parties, by the way.
Of course, yes.
Is it possible that over the break you could talk to each other to see if there are very precise areas where a request for disclosure could be met that you were happy with?
I think if Mr. Bowden would be kind enough to perhaps just jot down exactly what he has in mind. Yeah. I'm a great believer, my lord, in having something on paper so that I can actually look at it.
That there's no room for misunderstanding.
Right.
Okay. Do you want a longer lunch break? It's 2:30.
That would be ideal. Thank you.
Yes.
All rise.